like a lion on the prowl. Take back our kids, bring them home now. Constitution, strong blood won't lie. No more corruption, let freedom fly. Loud and on fire, won't back down. Keeping the faith here in this town. Apple pie dreams under a southern sky. American man with a fierce battle cry. Stand up, fight for justice, we demand. Gunning for CPS off our land. For family truth with a strong hand. Time to rise, take a stand. Corruption falls like shattered glass. Together we stay, no more broken past. Faith and hope, never too far. Return our kids, make them the stars. Fierce in heart and steady in soul. Families united, make the broken whole. Justice for all, America strong. Sing this anthem loud, sing our song. Stand up, fight for justice, we demand. Gunning for CPS off our land. For family truth with a strong hand. Time to rise, take a stand. Corruption. He calls it the reckoning. Blount County started it.
Blount County started it.
Kentucky doubled down. Gunner and Sharon are finishing it. Shadows where the black bears roam. They kicked in Gunner's door trying to steal his home. No war and no crime, just badges and a grin. But they forgot one thing, mountain men don't bend. He looked them in the eyes and said, you just signed your fate. You touched my blood, now feel the reckoning's weight.
In the Smokies roar.
In Kentucky we,
Hey! This is the reckoning. Gunner Evers calls it down. Blount County burning to the ground.
Kentucky CPS on their knees tonight. Retaliation thieves gonna lose this fight.
The reckoning is here.
Wake up America, draw me. For every stolen child, for every mother's tear. The reckoning is here. Sharon stood like stone when Kentucky crossed the line. Took her babies for revenge, thought they'd break her spine. But every tear she cried turned into molten steel. Forged a blade called justice that no court can conceal. From Maryville to Frankfort, the corrupt began to run. They woke the sleeping giant, and the reckoning begun. Now 1 million parents marched with torches in their hands. From the hollers to the cities, across these stolen lands. Gunner's voice on the podcast was the battle horn blast. Every episode another nail in the empire's casket. He named the day, he named the hour, he named the final stand. He called it the reckoning. Now it's sweeping the land. This is not politics.
This is not left.
This is not left or right. This is the line in the dirt where parents say, not one more child tonight.
Gunner Evers drew it.
Sharon Evers holds it.
America crosses it together.
When the last courthouse falls and the last black robe burns, when the last caseworker flees and the last stolen child returns, we'll raise a monument on the ashes of their throne, carved in Tennessee granite with these words alone. Here died tyranny at the hands of a dad and mom. The reckoning came, 2020 seats the storm.
This is the reckoning. Gunner Evers Poe in loud. Blount County in ruins. Kentucky in a shroud. CPS is finished. Hear the death knell ring. Every stolen child coming home on angel wings.
The reckoning is here. America, no more fear. Gunner,
Sharon,
your name's forever. The reckoning is now, and it's eternal.
the reckoning. Hey, hey, the reckoning. The reckoning.
Mommy and Daddy are bringing us home. The reckoning. The reckoning. America is free again.
Hey, look. This for every mama got her baby snatched on some bogus shit. For every pops they locked out the crib like he ain't blood. CPS, y'all been eating off pain for too long. We know what you on. But now it's war, this gun and foe. CPS. Kick doors, no warrants, they taking our seeds. Say it's neglect, but they planting they greed. Feds in their pocket, judge got a fee. Run it like a business, adoption spree. Contracts overseas, got partners in France. But shorty from Shy, he ain't get a chance. Mama work 2 jobs, daddy do right, but they still snatch his baby in the middle of the night. Fuck CPS, they ain't saving shit. Just a system full of snakes getting rich off kids. We see through the cap, we done taken the hit. Now it's Suffer Davis popping and we loaded the clip. Gunna got the case, now we in that fight. Taking this to SCOTUS, shining that light. They ruined good homes, now we flipping that script. Time to bring them back, time to empty the clip. They labeled us monsters, called us unfit, but it's they paperwork dirty, all of it forged and flipped. How the fuck they selling babies to a bidder overseas? Then tell the fam you unworthy. Man, please, we got mamas in pain, daddies in tears. They breaking our hearts, been doing it for years. Now we riding with Gunner, and we got the proof. Sworn under oath, now it's time for truth. Trump got the team and the pen in his hand. He said bring them home, now that's the plan. You feds been hiding, but it's over now. We moving like an army, and we ain't bowing down. Fuck CPS, they ain't saving shit. Just a system full of snakes getting rich off kids. We see through the cap, we done taken the hit. Now it's Suffer Davis popping and we loaded the clip. Gunna got the case, now we in that fight. Taking this to SCOTUS, shining that light. They ruined good homes, now we flipping that script. Time to bring them back, time to empty the clip. They ain't gods, they ain't law, they just people, corrupt people. And when the people rise, ain't no system safe. The Chi-Town, it's the movement. We gunning for CPS, and we coming heavy. Yeah, yeah, yeah. Wait, wait.
I'm gonna pull the whole thing down. I'm gonna bring the whole fucking diseased, corrupt temple down on your head. It's gotta be biblical.
Good evening, and welcome to another edition of Gunning for CPS. I'm your host, Gunner, and who are we going to piss off today? Am I pissing you off, Papa? Good. Guys, as you guys know, if you take and follow me, especially on Facebook, You've noticed this past week, we revealed to you, we showed you our actual filings, and we're going to go over it here tonight. What is called a Rule 60 in the state of Tennessee. Now, your state, even though it's not the same, this is a Rule 60 under the Rules of Civil Procedure, which family court is under the civil umbrella. Your state may have a section of its code that covers the same thing, but it's listed as a different number or a different rule. Okay, so let's be clear about that from the get-go. And every state is different. It doesn't take a whole lot of research. You can ask AI, search engines, this and that. Hey, I live in this state. Can you find me something similar in my state and my state code to a Tennessee Rule 60? Okay, and you can pick this stuff up. Okay, and we're going to address this. And like I said, there's been some great points. We've done a lot of research on this, and a lot of people, once again, with misinformation, saying, there's a lot of people out there that are putting out, listen, just work with CPS. It's the only way to keep your kids. I'm sorry, I'm not compromising my constitutional rights for anything, including children. And that is, if you're using children as a wedge to get what you want as extortion, how lower can you go? I mean, straight up, how low can you go to cover that? I mean, if you're going to do something, come after somebody directly. Don't use children as pawns. We seen a previous one last week that we covered, the Georgia Supreme Court, where Georgia Supreme Court, their panel, actually within this argument, and in case you missed it, says, well, we have contract law. If we've contracted with them, we're allowed to get away with these things. And even the justice that was there on the Georgia Supreme Court says, how can this be possible? This whole process is unconstitutional. Why Georgia, anybody that's in Georgia, didn't take that same video, even all the way up to the Supreme Court, and say, listen, these same methods, and even looking into that particular case, those same methods were used on me and my family in Georgia. I don't get it. Once again, you can enter the video as evidence. And you can put the case, like I said, present the filing of that particular case, so on and so forth, that decision. But to watch, not just read, to see that panel, those panel of justice, get so upset with these lower people from CPS having these arguments of what's allowed, the same way in the Ninth Circuit Court of Appeals, in the Hope versus Pellner case. This same thing went on. That thing went, broad all over the place. Where you could lie to steal somebody's kids, or hire an actor to do this stuff, to lie in court. These people, these are the same people that were, CPS is already known. Like I said, this is redacted, non-redacted, whatever it may be. CPS was mentioned, and if you look at all of them, there's missing pages, even stuff that with the release of the Epstein files, pages were missing if you followed the markings and everything else that was there. That's why some people had issues with it, but there are other places you can get unredacted parts of it, and it goes through it. CPS was mentioned over 33,000 times in the Epstein files. This is well known. How do you think they got the kids? They didn't magically all come in off of boats. No, CPS traffics, 100%. Crossing state lines, crossing counties. The whole point of children, when you remove your children from their family, from their culture, from their town, from their schools, from all these other things, you have now, psychologically speaking, and this is very well documented, caused a split within the child's psyche. Because this is their whole world. This is all they've ever known. Now they are on the big scale. And I don't know if some of the reasoning behind some of that was to push them into this one world order thing, or one government, or this thing that they were trying to push the whole world into, that has now been backfired, that now all across this world, we're revealing all the puppet masters and everything else that has been going on in our country and other countries, in order, including the jabby jab thing and other things and the lockdowns. These were tests. These were to see whether or not people would and which people weren't, and they gathered a ton of data. Who's their biggest resistors? And they then target those groups. This is all research. This is tests of what's it going to take to tip people, and how far we'll go. Well, I guess they pushed too hard, because now people are extremely pushing back. There are talks of civil war across the United States due to the fact of the arrests and everything else of everybody we now know in the Epstein files that's in there, of why they are not being prosecuted, arrested, this and that, regardless of their stature. Because if it's not the same for you and I as it is the president or a congressman or a senator, a governor, those things all apply to all of us. If it's not equal, then we're not constitutional. That's a huge problem, because that means those elected and appointed officials, the restraints we put on them with the contract law, also known as the Constitution, of what's allowed and what's not allowed, these are the rules you must follow, are even being ignored by states. Yes, even every state out there is violating the Constitution. Look at your policies, procedures, or even your local governments, the things they do. Run that through what is supposed to be done at every hearing, required by law, even by their oaths, is to have a constitutional lens to look at the first statute it has to go through, the first examination upon receiving a filing and the evidence that is proposed, is whether or not this is constitutional. Now, it doesn't mean a statute, policy, procedure, code, whatever it is. It's whether or not it's constitutional. And people say, well, they do this all the time, Gunnar, and I get it, they're not supposed to. That's where your state legislation is out of control. And they're not doing their due diligence to have the proper authority. Now, listen, I'm going to tell you this, a proper authority of having these bills or statutes or codes or whatever else is proposed, regulations, even this stuff with HOAs. Is it constitutional? Because if it's not constitutional, it's not even supposed to be on the books. And they say, well, states are different, they're autonomous. And no, go back to every state's constitution, its very own contract with its people here in the state. And it specifically says and acknowledges in all 50 states in their constitution, it's a requirement. It's even a requirement when they wrote it, to make sure that they acknowledge the supremacy clause of the U.S. Constitution. In other words, not only do you have to follow these statute codes and everything else, you have to follow the law of the land. This is a must. This is why your oath is so important. Now, we're going to explain something to you, and you'll get a lot of people that will come up, and now this is a cute one to turn around and throw back in the court's face, really to put them in check, especially state courts, is, a court may demand, or the judge or whatever, magistrate, whatever, says, you will address me as, magistrate or judge so-and-so, or your honor. And then, now hold on, let me explain this, because we're going to go into a historical lesson on this. I cannot address you as your honor, because from my perception, you have no honor, because you have failed to uphold your oath to the U.S. Constitution, that you have no honor. By not honoring that oath, therefore, I cannot say your honor, because I'm literally going based off of, hey, I'm leaning upon, when I say that or addressing you as that, your honor is that you have honor. But if you ignore the Constitution, then you have no honor, because you have not upheld your oath. So I cannot address the court as your honor, because historically speaking, your honor, you had to act with honor. And from my perception and what I've seen, You have no honor. Matter of fact, administrative law judges were, before they started addressing themselves as judges, were considered justices of the peace, showing that they weren't the same as a judge. They renamed themselves. Look at history, go back to your research on that. And the same thing with the robes. They started wearing the robes. No, true judges, and that's why it turns around and says, it was talked about even in case law that true judges are not found since a certain year. Why? Because the administrative law judges overtook some of that stuff under, once again, there's talk of corporation to set. That's why if they're going to treat you like business and you're going to have that conversation, the thing is you need to shift your perspective, okay? And this is why. Because if they're going to treat you like a corporate entity, then you need to understand the rules of corporate law or corporate contracts. CPS can get away with things if they get you to sign away your rights or contract with them. Let me make that clear, and I want you to hear me again, and this is why you need to educate everybody. Don't sign a damn thing with CPS. Knowing this, and you can even go back and turn this on them. I didn't realize I was signing a contract. Once again, part of contractual law is that both parties must fully understand what it is they're contracting to. Now, when you contract to so many things with CPS and then they change things up and this and that, no. This is why we tell everybody, get it in writing. So if I'm going to contract with you, CPS, I need to know the exact things you're going to do and break it down and blah, 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 blah. This is and you got to put that in writing. And like I said, that covers your butt. What do I expect out of you and what do you expect out of me? I need it clear. I need it explained to me clearly. Because if I don't, it's a violation of your state and federal contract law. I want you guys to understand that. Now, this is something I come across this particular week. When corruption gets so bad that a grand jury says, oh no, you need to take, and not just, let's just deal with the criminals here. Your whole police department needs to be indicted. Watch this next video.
Of an Alabama police department was put on leave after a grand jury found them to be operating as a criminal enterprise. Color me shocked. The Huntsville, Alabama Police Department has already had 5 of its police officers arrested, and a grand jury recommended that the entire department be abolished. The department's chief is amongst those who were arrested for deeply mishandling evidence. So much so that pretty much any evidence that has touched this police department is completely unusable. They all have also been charged with a variety of other offenses, including the misuse of state criminal databases and the distribution of controlled substances to each other. The grand jury called it a, quote, rampant culture of corruption that should be immediately abolished. Huntsville is a city of about 3,000 residents that is around 45 miles north of Birmingham, and its residents are completely not at all shocked or surprised that the jury came to this conclusion. With one resident saying, "It doesn't shock me. It shocked me that we're trusting people with our lives that shouldn't do that." The entirety of an
That's some mass-ass corruption, folks, and that took what? Somebody standing or somebody filing enough charges to get to a grand jury to hear their story. Maybe focusing on 1, 2, 4 or 5 individuals to enough to say, no, the whole department should be taken care of. Now let's explain something. So a lot of you guys don't understand maybe, and we're going to clarify a few things. There are 2 different law enforcement entities that people know about today are called law enforcement, and they're not. Let me clarify. A sheriff is a duly elected person by the people of your county within your state. And their job is to protect you and your constitutional rights, the people, that's what they're elected to do, even against the state. Because this has been a mass confusion, okay? A lot of sheriffs think I answer to the governor, I do this, I do that. No, I help institute or I assist with some of those things. You have the state police for that stuff. Your duly elected sheriff answers to the people. His direct boss is under the administrative powers of the President of the United States. Boom, done. That's who they answer to. That's who they get their directive from. They are almost a federally based, you would almost consider them a federally based system to oversee that. Now, that corruption has penetrated many sheriff's departments across the nation. Now, let me explain the difference. A police chief or a police department does not answer to the President of the United States, the executive branch. They answer to the mayor, which is a private entity. Your city is, you'll notice it'll say it was incorporated here. It's a business entity. Doesn't deal with me and you. Matter of fact, they're not supposed to be dealing with you. You're dealing with corporate law. That sense of entity is local to establish the things for the government to regulate or crack down on things that are commercial. Business to business, not you and me. Complete different set of things. That line has been crossed over the years from mass corruption on higher up levels of each of your states, to where it says, well, the governor can force you to do something else because I mandate this and that. There's a thin line between that. Okay. That's called separation of powers. Okay. The state cannot give, they can ask for help from the sheriff, but they cannot take direction from sheriff because that's a conflict of interest between the governor and the President of the United States. And everybody goes, well, what are you talking about? Yes, even some states have put out a training manual for the sheriff, says you must follow, this is our state thing of this and that for our incorporation. Well, we don't care to assist. But my primary job is the people that live in my county and protecting their constitutional rights, even from businesses, even from the state government. That's their job, but they haven't been doing that. Instead, they've been roped in, especially with CPS, to come out and threaten and or intimidate. I'm here as a peace officer because something's going to go off. Why would you think something violent's going to go off if working with them is voluntary? And that if I don't work with CPS, which every state says there, it's voluntary, then why are they able to take you into the courts if it's voluntary? And I disagree with you because I'm not contracting with you. That's why they're so after, so quick to get you to sign something, anything that gets their hooks into you. Now, we're going to go over, like I said, tonight, and if Darren's back there, he's more than welcome to join me. We're going to cover tonight what's called Rule 60 in Tennessee. Now, every state has got their own section of rules of civil procedure. This one is Rule 60, I believe. Kentucky has, I think, the same code, if I'm not mistaken, under a Rule 60. Illinois has got a different number for that. And once again, they mimic. A lot of states were really lazy when they wrote their policies and procedures and everything else. And basically, they're like the kid in class of, here, let me look over your shoulder and I'll change a few words, but it's original. No, it's not. You copied off somebody else. Same thing with state constitutions. It's well known that a lot of states are just that damn lazy or didn't understand that you had to go in. Why? Because that's the one that got passed and that one was good. So let's just copy off the kid we know that passed rather than being original, and flexing the originality of your state. But a Rule 60, I just thought you guys would find that amazing that it's so bad. Now we're gonna deal with a Rule 60, and this is gonna come up 6002. Now, like I said, it's different for each and every state. So watch how this applies, because you're gonna have to. And once again, it's easy to find this for your state. You just simply go. You can use an AI, you can use a search engine, and generally it's going to bring something up right there. Say, hey, I'm in Michigan. Give you an example, Michigan. I'm in Michigan. Find me within my Michigan code something similar to Rule 60 of the Tennessee code. And automatically it's going to bring it up what it is and how it is, and you'll go through each line. Now you have to read these very carefully because they're very stringent. Okay. Now I'm going to bring it up right here. Once again, this is on the Tennessee courts. This is direct from the source, just so we know this. Rule 60. And I'm going to make sure you guys, let me see if I can, because I have to go back and forth between screens here. Let me see if I can't. Can I zoom this a little bit? Maybe try this. And I don't know if it'll center it. Oh, well, let's, I think that, let me see if that made it big enough for you guys. Yeah. Well, guys, I'm going to take down the comments here for a second so we can go over this, and then I'll turn you back on. Looks like Miss White's the one that's here for us this evening. You guys, we've got some people out in the audience, but I don't know if Facebook's coming through. So if you guys are watching on Facebook, try and make a comment. And if not, after the show, I'll go back and look at it. We thought we had that fixed, but now we're not so sure. It comes and goes. Okay. Rule 60, Rules of Civil Procedure. And once again, this goes through 60.01, 60.02. We're just going to read it verbatim through here, and so you guys get the point. On motion, and this is even after your case, you've had your judgment and this and that, and you realize everything you went through is just corrupt as hell. No way did they follow their rules, their policies, their procedures, the whole thing. In other words, the law, in other words, it wasn't followed as it set out, and it's designed to do because people failed to do their job. And because they failed to do their job, they've either committed extringent fraud upon the court by not doing their job, because had everybody had done their job, or multiple people done their job to turn around and do it, you would have not got the same ruling. And that's what it looks at, is specifically, okay, we know now that those things have not been followed. You're now pointing out the things in your Rule 60 filing that weren't followed, or things that weren't done. Then you come back to the court and say, listen, they didn't do this, and these are major, especially like rules of evidence, stuff that should have never been entered. The using the constitutional lens that's required, that is also required. Once again, you have to state once again in the filings and in court, once again, defaulting back to your own state's constitution, that yes, you must follow the Constitution. It's right here in your state constitution that defers back to the Constitution of the United States of America. Once again, you have got to cite it. Make it easy for them. Use the dumb thing, because once again, most of them aren't even writing their own decisions. They're putting it on the CPS attorney to write, and then when they get a hold of it, the judge just looks at it, goes, okay, and signs it and goes about. That's a huge mistake. This is why judges should never have anybody else write their stuff. And once again, they should be penalized for that. I don't even know if that's legal. And once again, that's going to be brought up in mine, because we know who wrote it, because she said it right on the record. Hey, write that up for me, and then I'll go over it and I'll sign it. Why is an attorney doing your job, Judge? I got questions. So let's go over here. On motion in such terms as are just, the court may relieve a party or the party's legal representative from final judgment, order, or proceeding for the following reason: a mistake, inadverse, surprise, or excusable neglect. In other words, hey, this is here. You've got it under number 2, fraud. Whether hereunto denominate intricate or extrinsic fraud, misrepresentation, or other misconduct of an adverse party, such as massive perjury. The judgment is void. Why? Because, then you explain it. This is where it would tie into what Darren talks about a lot with void ab initio. You file it this way. This is where you do the void. This is why it's void. But you can't file it in the lower court, is what we're finding out, especially in Tennessee. You have to, during any time, like I said, do a Rule of Civil Procedure, a 60.02, file this complaint even while it's going on, saying, I'm not getting a fair trial. This is what's happened so far, and this needs to stop. You would then file on that particular court, the same lower court that you most times in most states, you have to file your appeal to go in there. This is a version of the appellate process, believe it or not, but they don't talk about this, because the reason is, when you go after this, you go after the system. When you file a rule like in Tennessee 60.02, you're talking about extringent fraud. You're talking about this. You're trying, and once again, when you're filing, you have to prove it or put it out there so blatantly. How could you have missed this? Or you could come through and say, hey, the judgment's been satisfied, released, discharged, prior judgment, this, that. It's no longer equitable, this, that. To have prospective application, you guys can read this. You could find it. Once again, it's a Rule 60 under the Tennessee courts. You can find the same thing here. Just read through it of what it says, okay? And it says here, a motion under this Rule 6002 does not affect the finality of a judgment or suspend its operation. In other words, it's the court's discretion. But the court may enter an order suspending the operation of judgment upon such terms as to bond and notice as shall seem proper. In other words, every case is different. Your case doesn't always meet that criteria, depending on how bad you got it, will come in this. Now, it doesn't limit the power of a court to entertain an independent action or to relieve a party from judgment, order a process that is set aside a judgment for fraud upon the court. In other words, saying we can give you complete relief if there is fraud upon the court. Now, it talks about writs of error coram nobis, okay? Now, this was said to me somebody else when we went down this. It is addressed in the Tennessee Rule 60, okay? Bills of review and bills of the nature of a bill of review are abolished. In other words, they're saying they're not taking this. This is a, once again, we're going to jump over. We'll look over here once again over here. Let's see if I can get this pulled up. And we're going to go to, whoop, I got to close that window. Give me a second here, folks. Let's hide that one. Let's add another one. Hopefully my thing does this and it doesn't screw something up. Okay. A coram nobis. Okay, let's get into that. Let's go right into, Wikipedia is a decent source, but once again, it's probably the most. It's under common law. Okay, so you got to watch what states are doing, whether or not they have something in there to see whether or not you can file this particular writ. Well, it's telling you within that code, we do not entertain such writs. So somebody may say, hey, you need to file this particular writ. You got to go back into it to make sure you can even file it, because once again, they don't acknowledge it. It says right here, the writ survives in the United States in federal courts, in the courts of 16 states. Tennessee is not one of them. Okay, so you got to look for your state. You can go through the history there. Not a problem. But once again, do your own research, because like I said, it goes back and it says it specifically addresses it within the state code. They don't cover this. They don't acknowledge it. So you have to proceed on a different way. Okay, you got to find a different method. Now let's go back through this. There are different types of Rule 60s. Okay, I filed a 60.02. Okay, you can file a 60.01. Now this rule, it talks about how it supersedes the code, and that was repealed, and all this other stuff consistent with the purpose of those statutes and this. In other words, you have a clerical error. In other words, a he, a him, a this, a that. There's a clerical error. In other words, there's something in there, a name's wrong, this is wrong. You can petition the court to have that corrected. That's a clerical error, basically filing is what they call it. Now, a 60.02. In Tennessee, this is the one that says, uh-oh, we got massive problems. This rule subsedes, and it tells it what it supersedes. In other words, don't worry about this particular Chapter 7, Title 27. This supersedes it. In other words, it's more powerful than that section of the code. And it's dealing with the writ of error cornus and Tennessee code, both repealed, dealing with abuse of review. A committee felt it was better to bring together under one rule the subject matter formerly covered by these statutes. In other words, hey, let's get rid of all that other stuff. Let's just combine them, throw them together, and we'll deal with it under the rules of civil procedure 60.02. We'll file it as that. And you're going to find how it evolves over time, which goes through your state's history of, once again, rules and policies and procedures of how throughout time a case has maybe changed this or a ruling changed this. So now they have to go back and they have to amend it, or they say, listen, it's been repealed. In other words, it's no longer active. We repealed it. In other words, it doesn't exist. So instead of just omitting it, which is what they're Well, a lot of them will try and do, well, let's just omit it. No, 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 you have to put in that it was repealed. Okay. And you have to understand the premise for what it was appealed. Okay. Now, until that's, repealed again or overturned, which somebody else could come in with something different and overturn that, reinstituting that. That's the powers of the courts, is to go through and have those, conversations. Now, we're going to deal with something very unique because I had a unique situation. The advisory committee comments. So Rule 6002 provides that a motion filed pursuant with the rules shall be made within a reasonable time and for the reasons and not more than 1 year after the judgment preceding the entertainment. Now, one thing that they're not taking into account for, and I'm going to tell you this thing, with this 1 year, look what it says, reasonable time. This was done off a Supreme Court filing that held a reasonable time filing requirement rule of this does not apply to petitions seeking relief from void judgments. In other words, I want you to void the judgment. In other words, there's no time period. You're talking about fraud. Why? There's no statute of limitation on fraud. That's why. I hope you guys caught that. There's no statute of limitation on fraud, federally or state, automatically. Same way as there's no statute of limitation when somebody violates your constitutional rights. So if you fly the flag and say, listen, we got a problem because reasonable time, but this is not a year. Well, wait a minute. The reasonable time thing says right here and under that ruling. So if I have an ADA violation that I was in medical crisis and I can back it up with medical records, such as with mine, congestive heart failure, it was going on before the hearing. It was going on during the hearing, which I received 0 ADA. Okay, 0, which the clerk failed to doing that. Even bathroom. Now, here's with congestive heart failure, the biggest thing you usually deal with is water, retention of water. So when you have to go to the bathroom, you need to get that water off of your body. Once again, they're not practicing medicine, but well, Gunnar, how do you prove that? Pull your medical records. See, when you wave the ADA flag, you give that to the clerk. The clerk then has to abide by HIPAA, and they have to provide you with ADA. They have to notify the court of ADA, but you don't have it all out in the court. It's not for the judge. It's not for anything else. This is why it was given to the court clerk. It's the court clerk's responsibility, as Henry would say, who's your duly elected representative for this county? Who do I have to meet with that has the power to get me what I need? And it's the judge doesn't have a say in this under the ADA. Okay, this is massive. Okay, this is outside the court. This is something the clerk does. And if the judge says, well, what's the problem? Well, what's going on this? I'm giving them ADA. Well, what's the problem? I can't discuss it. It's HIPAA. Now the judge is completely out of the picture. Okay, I've got an ADA issue. So I need to double check with your designated person that's supposed to be watching my whole case. The judge, there's certain things you're going to do to where your ADA person is supposed to be in the courtroom and say, Your Honor, we can't proceed. We can't do this and that. Or Your Honor, we need to stop. Why? Because we need to have a bathroom break. Or we need to do this, or we need to do, this or this or that. That is required by every state and federal government agency, and they receive grants and all sorts of other stuff to do this or have this system in place. And they do not. And that's why I'm telling you guys, that's where you get in under the radar with stuff of saying, well, wait a minute, what's reasonable? If I'm going through cancer and I get on the other side of cancer and it takes a year or two to get through it, that's reasonable under the ADA and does away with that one year rule crap out the window because it wasn't reasonable. I couldn't do it within a year because I was recovering from massive heart attacks and had a pacemaker put in. How could I do that? They have to take that into account, but you have to articulate it, then prove it. And we had all the forms and everything else. Like I said, when we filed protecting the HIPAA, putting it on the court clerk where it belongs to assign the person or notify the person of this with the initial filings. We're going to need ADA accommodations. No ADA was also given at all. So now you've got another huge problem, because now you've got failure of ADA. Now, failure of ADA, if you go listen to Henry over there at Equal and the Same, he'll tell you straight away, that's a violation of due process. That's a violation of your constitutional rights. Why? Because you were put in a weaker position than everybody else in the courtroom to stand up for your rights. That will get you past that 1 year thing. And by law, it should. It has to. Just claiming the ADA. And once again, a state can't make that judgment under the ADA because it's federal. So if they don't believe that it should be enacted, well, then the state would have to make the argument, not deny it, but the state would then have to file a 1983 bylaw to answer that question of reasonable time. Once again, common sense is going to go through this and that and say, well, we're not going to put it. No, the state can't. The state must just follow. They can't interpret federal stuff. They don't have the power. And if they do so, that's an act of treason. Why? Because they're stepping outside their wheelhouse. You're an administrative law judge. You are not a federal judge to make, you're out of your jurisdiction for you to make that. So you can argue right away, we have a jurisdictional issue if you're going to bring up that question or challenge that. And the state needs to file with their complaint to clarify it. Then you put it back on them. It's not up to me to do that. I know where I stand. You have to apply the law as it reads. And the federal codes, it's required. It's required under your oath. It's required under your oath to the state constitution, because the state constitution defers back to the U.S. Constitution. But once again, with these idiots, you got to draw this stuff out with crayons. You got to put it in your paperwork. You got to. There's no way around it. And I'm hoping, let's see if this works. Nope. I think we're going to have a problem here, and I don't know why we're having that problem. Let me see if I can open this a different way. I was going to show you guys, and maybe it'll come up this way. Like I said, you'll have to forgive me. Some of the restream stuff, they have been doing some updates to the system, and like I said, sometimes it's kicking things out. Let me try it again. If not, I'm going to try and open it. Where'd it go? Now we got a problem. Okay, let's can't share screen, this and that. Oh, something with the help center. Oh, great, that was fun. Let me try it another way, because I have two different things for sometimes because of proprietary things it won't. You know what? I know of a way I can do this. Once again, it gives me a minute, but I'll figure it out. Yes, I understand it won't do it from Help Center. I'm going to go to, and you guys can go back there with me. Once again, go to my page if you're friends with me on Facebook, Gunner Evers. Once again, on Facebook, you're going to see it. Once again, we're going to go to, let me find this. I released it earlier last week. Once we filed, I think we put it out Tuesday, where we were expecting to do Monday. We had to file Tuesday. We've got some other updates we have to file too, some amended versions of stuff going forward. But we put our initials in just to get them filed. But this is a powerful tool of a Rule 60, because what you're able to do is say, listen, either the court process I'm going through, or the court process I've been through was so corrupt, and we're going to show you why. Let me see if this will, I believe, yep, I can fly. Okay. So you're going to address everything, and we'll go through and we'll explain some of these things. Let's try this. I opened it up through the Facebook, so let's see if it will. Well, let's see if it does it. There we go. Dun, dun, dun. I believe we found it. And let me get the comments back up, guys, because now we can see this as we can interact together. And seems like everybody's a little quiet. a little bit tonight. Amy comes in there. Maxim of law, fraud viviates. Yeah, it's a maxim. That is correct. Let me zoom into this a little bit. And once I get this done, and you're going to see where it's filed, the whole 9 yards. Let me see. Let me expand it again. Okay. Look at what this says and how this is the format, okay, that you have there in Tennessee. Now, it does probably need a few little things such as, well, it's double space, it's this and that. I haven't had a problem, like I said, with anything like that. Once again, you're pro se, you're not going to get everything right. The court will allow you to correct certain things. But if they're going to be anal over that, it's not federal court. And if the other thing is, too, if you have a problem, just go look at a filing from one of the other attorneys that are actually in your area and say, well, you accepted this and it's in the same font or it's in the same this and that. It's not really that big of a deal. You're just nitpicking. And that wasn't it. Because if you're going to reject mine, then you're going to have to go through an audit everyone that had the same problem I did and reject them for the same reason. Yeah, they're not going to do that. It's too much work and it costs them too much money. So that's why a lot of it just skips through. But let's turn around and let's look at this. Amended motion from judgment under the rules of civil procedure. Let's see. Oh, we lost it. So let's zoom in again. I think you guys can look at it here. Double check. There we go. Okay. Comes down motivated here that, vacated a restraining order, that's all they have, but they use criminal code. Here's you start out with your statement of facts. Okay. Yeah, you're saying severe child abuse. Well, we're turning around and saying that if you had severe child abuse, for this and this and that, for you to claim these things, which goes under these particular things, where's the professional? Because if not, the court is acting as though they're practicing medicine without a license. Where is your medical profession, your state licensed medical professional, the MD, somebody that is considered once again, an expert witness almost of sorts? Under this thing, when you use these codes or you're using these things, if you'll see, they use the code TCA 371-102B-27. Now, when you look this up, this is what's funny. This is the criminal section of the code. Now you understand why I claim that, once again, in the filing, they violated the state's constitution. Why? We went over that. You have got to be, no person shall be held accountable for a crime unless you've been presented, indicted, or impeached. I've never been presented to a grand jury. I've never been arrested. None of these things have happened, but you're trying to hang a criminal code. Now, 27 has several subcategories, A through F, okay, in this code. They're saying I did all A through F. Well, for them to do these things, one, to say there's bodily injury or this or that under Section A, where's the doctor's report? There wasn't one. Okay, B, you have mental things. Okay, who is the one that took and testified about that? A CPS worker is not qualified, nor do they hold the license to do these particular things. They have to have a state-issued license to practice those things and even see, we'll say, the client or the person. None of these ever happened. Okay. Commission of acts, and it goes through A, B, C, D. Presence of the child where methamphetamine was created. Well, guess what? There was not anything even brought up, even any criminal charges, even police report or anything, that a child was within a structure where methamphetamines was being created. It doesn't exist. Nothing's on the case trial because it never happened. Once again, this is extringent fraud because you accused me of A through F. E, ingestion of illegal control. Where is the medical report in the drug screen that's required to convict me under E? It doesn't exist. Presence of a child within this where a Schedule I substance, cocaine, meth, or fentanyl are present and accessible. One, they never had a search warrant to even come in my house. That structure that they're talking about or anything else, there's no police report on this. This is all fabricated. Gotcha. Guess who wrote it up? That's right, the CPS attorney. Why? Because they wanted to ruin somebody's life. Right here, motive is severe that no medical records, drug tests, or evidence were entered, nor did any medical or psychologically licensed doctor, you got to spell it out for these people. to any bodily or psychological harm on the record. In other words, it's bullshit. 27A through C would mean that the state and the courts were practicing medicine without a license. Calls them out for it. No evidence was put on the record of any drug of any kind to warrant such finding in subsections. You're pointing it out and you're shooting the holes of why. These are the things that are required that this judge, sitting judge, was supposed to know. But yet she signed her name to it. Somebody else wrote it up. It says right here, following this, under this particular code, the finding of this must be supported by, once again, we're using the state code, not the federal, clear and convincing evidence under the Tennessee code annotated. These are the rules of civil procedure. Abuse of this requires specific proof of this in the presence of this. None of it's on the record. It doesn't exist. Wait, here's a Tennessee court. Here's a ruling. Court of Appeals, same thing. The clear and convincing standard. Listen, guys, learn this right here. Find where it says in the civil code that clear and convincing standard must exist and they must meet it. Why? Because that hearsay bullshit goes right out the window. Because this is the standard within your code and even a court ruling that clear and convincing evidence must be present. When they make the finding with zero medical on drug tests or this not constitutes, here's the trigger word phrase, fraud on the court. Because they led the decision to reach the conclusion without the necessary legal precedents. Ouch. Now let's go into this. Furthermore, no criminal charges, presentments, indictments, or arrests were ever filed, rendering the court's finding of a violation of Tennessee Article 1, Section 14, which mandates no person shall be put to answer for a criminal charge. In other words, using criminal code, but by presentment, indictment, or impeachment. It says right here, I have never been arrested, indicted, or arraigned, or charged, or convicted of any criminal acts which this court has stated as facts in its final orders. Done. It goes even deeper, guys. Why it gets even more. Sole evidence was based on that stupid forensic interview. Now, things have been redacted on this for a reason. I'm showing you the redacted copy here because, once again, protecting the children like they're supposed to do. It says right here that affidavits this bringing the child was never or interviewer was made unavailable for cross-examination, which violated TCA 24-7-123. And look what it says. Revised effective July 1st of 2025. It's still new. You still have a chance to file if you're in Tennessee and you did not get cross-examination. On top of the fact they withheld evidence. Look at the filing, guys. Before Neurat things suffered from a severe medical crisis. Heart failure, no ADA accommodations. You got to spell it out. I wasn't given ADA. That's automatic due process violation. Now, let's go to the constitutional and statutory that goes through these things. And this is how this goes. Look how we've stated this. The guys, this is on my page. You can look it over at your same. Find cases that have similar rulings. Go in and ask your AI or your search engine. Find me a case that's similar to this in its ruling from my state, and then you can use it. Once again, read it yourself. Okay, and then we have some federal stuff in here under Crawford v. Washington. Why? Because we're going to deal with jurisdiction. Okay, child wasn't available for cross-examination. Now under Crawford versus Washington, statements are inadmissible. Why? There was no opportunity for cross-examination, and stating because the child did not testify at trial in that particular case, wasn't there for cross-examination, the child's statements are inadmissible under the rules of evidence. The Child Welfare Agency then failed to present clear and convincing evidence that, so if you've just got a forensic interview that they're trying to use against you with this and that, no, child wasn't there for cross-examination. It automatically says that, it says if there's not failed to meet the clear and convincing evidence. Now, this is in a CPS case that the child had, they failed to meet the standard to say the child was ever abused by not allowing that. Now you're saying, well, this is a loophole for people to get. No, I'm telling you the due diligence of the reason it's there is to cross-examine. You have the right. Now you're looking at fruit from a poisonous tree. Now watch. We point out the fact that the Tennessee Facts Report, which is the CPS report, was turned in. The been in the house and had done this and had done that and talked with the children, this and that. Well, now we call them out under jurisdiction. Why? This is Fourth Amendment. I don't have to use state case law. I can use federal. Why? Because it's the only one that has jurisdiction. Violated that in Homestead. It says Ninth Circuit right here, White versus Pierce, Ninth Circuit, and Doe versus Heck. It goes about the Fourth Amendment and these things that, one, you entered without a warrant. Number two, you have a seizure under the Fourth Amendment by just asking questions. They can't even ask you the color of your socks. That's considered a Fourth Amendment violation of seizure. The case law supports it. And the Fourth Amendment case law and the amount of case law that goes with the Fourth Amendment is stacked so high. So high. It's unbelievable. So we say, well, since this started with a CPS worker coming into the home and committing several Fourth Amendment rights violations, we're now calling out that all evidence is derived there is inadmissible under the fruit from the poisonous tree. The judge should have caught that when she saw he'd been in the home to say, where's your warrant? I see you question the kids. You realize that seizure? Did the court do any of that? No, but they're supposed to enforce federal case law and the Constitution. They can't interpret it, but they can quote case law and say, listen, I have to follow this because I'm required to, because you've quoted federal case law to back it up. And unless that's been overturned, or they come back with some sort of exception to the rule or anything else, which there's not under these circumstances, it doesn't exist. The stuff they do, it's not even about it. Why? We've looked at it. We've dug. Several of us have dug through this. None of it. And there's no evidence. Here's the other clue that you drop in there. There's no evidence was put on the record of any form waiving any rights. In other words, you go in for criminal, you go in for this, you go into that. Once again, you come right back to it. Where did I sign away my rights? Show me where it was clearly communicated to me that my Fifth Amendment did not apply. I didn't waive any rights because I have my Fifth Amendment, so I have to waive my rights. There's nothing signed waiving rights. Show me where it's at, because it's not. That would be the thing. If not, you have to follow the case law. Every state or federal government representative, it doesn't matter who they work for, to enter somebody's house must have a Fourth Amendment. Now, hold on now. You guys are going to love this. We also call out the fact that the CPS worker handed over a client's right handbook, is what it's called in Tennessee, dated December 2016. It states specifically on pages 6 and 7, second paragraph, that entering the home and questioning children with no mention of warrant, but does say a person under investigation, your consent is not required for an interview to take place. You're probably right with some of that, but also you're going to have to deal with the fact that where was the child's attorney for when they were questioned? Because they do have constitutional rights under the Criminal Resource Manual that the Department of Justice puts out, CRM 121, specifically addresses Fourth and Fifth Amendment rights of juveniles. And once again, there's also case law to back it up. It's all in this. Look through this. Yes, even the caseworker that we had forged my name trying to look like I was contracting with the state, then lied in court and said, well, my attorney said I could sign it. My attorney looked at him and we didn't have a separate hearing on it on top of it. But once again, you didn't. Now, once again, you're going to go through this here, misconduct for the guardian ad litems. Yes, we had this, and yes, that one of the guardian ad litems did away and told Sharon not to bring her kids in the courtroom at all. That's a violation of 24-7-123. But if you'll also notice, My attorney, which was Mr. Baker, questioned the court regarding the presence of that particular child and saying she wasn't on his witness list, then the child would not be available for cross-examination or for questioning. Well, that clearly violates the judge stood in the way of TCA 24-7-123 of the rules of evidence. To enter the forensic interview, the child has got to be made available for cross-examination. That is a blatant disregard for the rules of evidence. This judge is cooked. Then you have the thing with the children. No attorney was present for when questioned by the forensic interview, all, the kids. The DOJ acknowledges this right here, and there's the CRM 121. Hold on. This deals with constitutional rights, so the state can't rule on it because they don't have jurisdiction. They must just follow, remember? And in the Supreme Court ruling found in Regault, 1967, and still on the books, and marked as a landmark case. Because if all this was done, we're saying, then fruit from a poisonous tree should have automatically been applied, and I should have never been in court from the very beginning because they committed a constitutional rights violation and later on continued into it with criminal acts, let alone bring it into the court under fraud because you knew you weren't supposed to go to court because you had violated the constitutional rights. The CPS attorney should have known that from the filed paperwork. That's the argument that goes with that. You should have known, and you can't claim ignorance if you're getting paid for it as a professional. Otherwise, there goes your license, buddy. Uh-oh. Here, once again, now look at here. Failure of this and that to mandatory order of medical record. In other words, the GAL and CPS all had under the code. And we found the Tennessee rule that goes in because there's codes within your state law that deal specifically with CPS and juvenile procedures. And that's under Rule 40. They were supposed to obtain a court order from the judge for all medical and mental health records. They never applied for anything on the record. None of it. They wanted to keep it out. Why? Because then you couldn't hint at something psychological going on with a child that was developed and been through dramatic trauma, such as losing a father to a heart attack or COVID-19 lockdowns, or some of the other things that the children had been through. But yet the GAL that was on the case as protecting those children failed to do it. Matter of fact, when we went before the magistrate, none of them had even, Miss Jenkins never even met with my wife or her children, and yet stood up in a court on people she doesn't know, very, very clearly showing her bias in favor to CPS rather than doing her due diligence or her required job as she was paid for by the state. Now, where that then becomes the question, where do we protect the children if we flush their constitutional rights? That should be the highest thing for both this and that. Now, understanding Aaron Schott was the GAL for my son, and let's correct this. Aaron Schott is now the magistrate that took the place of Jason Bedingfield in Blount County, Tennessee. When he stepped down, Aaron Schott got his place, and this was right after my trial. You think there's any favoritism or anything? Boy, they're going to hate this state and federal investigation coming up their butt. Yeah. So now we've got rules of judicial contact, Rule 10. And now we're dealing with canons. Now, listen, this is where you can really mess a judge up. And I know you guys may not think it, but here's the thing. You may not know it, you may not thunk it, but and I don't know why this thing's working and then not working. Maybe it took it over. Let's see. I see James in there. I guess I'm spammed out on my side as far as maximizing. So you're going through and you're calling them out under their own state rules. And you're explaining it clearly to the court who screwed up, how they screwed up, and what their job was, and was it done. This last section is for the judge. Denial of right to be heard. This is a judicial canon. In other words, it's a must for every judge. Undermining the public conduct. Why? Because you didn't do your job. Now you're under Rule 6002, number 1, number 2, number 5. We've said you've broken 3 of those and clearly articulated why. And that's why we're moving towards not just overturning a case. Guys, this isn't about overturning a case. Let's make this abundantly clear. We're not talking about overturning. We're talking about void. Void. In other words, it should have never been from the beginning. It's like the void ab initio that we talked about before, but now you're bringing to the appellate court of saying this hearing was so corrupt and so bad. I don't want it overturned because it's on my record and then I got to deal with all that other bullshit. No, I want it voided as though it never existed. This is the power of a Rule 60. You know, once again, your state may be different as far as what the rules of civil procedure. But let me tell you something. Those judicial canons, and that's right. Absolutely, Amy White there in the comments, guy. Those judicial canons will fry a judge. You've now got a judge on violation of judicial canons, rules of evidence, rules of interfering with evidence directly, not just indirectly. Oh, there was a little error. No, you participated in the crime. Judge has got to go. Judge has got to go. You cannot, you should have never been placed on that bench if you're this grossly negligent of all these. And you let it go on, which means what? Now I've got you for RICO because instead of siding with the law, not just me, not just me. Let's make this clear. It's not about me. You didn't follow the state, your employer. You didn't follow the guidelines and restrictions that were given to you by we the people by following the state's constitution. You violated it. You should have thought of that before you had somebody else write that up, because right now, what you put against me, there wasn't even evidence even brought into the court to even say any of this, let alone one single professional on the court. I've now got you bent over a barrel, and you as the judge, as the, I forgot what it was, Amy, that we talked about. The judge is the kind of like the microscope. They're the fulcrum of balance between there. In other words, they're supposed to be looking out and doing certain things that they didn't do, especially protecting my constitutional rights, protecting the constitutional rights of the children against our enemy, which is the state in this particular case. There's Richard. Yeah, I can see you on Facebook, so we are getting a little bit through there. So you guys have to look at this now. This is once again, this ruling or this particular hearing that you're filing for goes through the Tennessee Court of Appeals, okay, in a way. So they're going to assign a special judge to hear this. And this whole hearing isn't about revisiting the case. The whole basis of this hearing is how bad that they didn't do their job. And once again, there's nothing they can argue or go back and forth of because it's on the record. And it's an analyzation beyond that. Now, before, say from this particular thing, this doesn't work here and there, you can then also call for a complete review of your case in every state by going to and filing for a judicial review by the Chief Justice. That is the member that is elected for so many periods of time within your state to sit on your state's Supreme Court. Okay? They elect one person to be the Chief Justice. I think here in Tennessee, it's 3 years. So any of those reviews, that has to go through his focal lens. Now, this still preserves your right to appeal, including the judicial thing, the right to appeal. And even, I believe it's a Rule 11 in Tennessee to go to the Supreme Court and say, I don't agree with these, or there's something massively corrupt. I need to bump it to the Supreme Court, and I'm asking for the panel to hear it. Everyone except for the Chief Justice. Why? Because they've already looked at it. If you're, okay, What are you looking for? A copy of what record? Because when you file a Rule 6002, you file with what you have or enough with what you have. And then you have the power of subpoena still to prove your case, including ex parte communication. Yeah, and the judicial review is before the appellate court, is before you go to an appeal. I'll say that is correct and point that out and make that very clear. So don't skip a step and wipe yourself out of a judicial review and go straight to the appellate court. Like some attorneys will screw you up, and then now you've lost your Rule 60 filing, you've lost your judicial review. So if you go to there and it moves forward or anything else, or something's kicked back, now you can refile. Say if it's kicked back, completely different. If it's your case, op wipe tears, you still have the power of subpoena under a Rule 60 or whatever it is in your state, and you can subpoena all of those rulings, all the documents, all the forensic interviews. The other thing that was not made available as well too is the forensic interviews of the other children. My wife and I have still never to this day seen those. They were withheld, so that's withholding evidence. But once again, you got to pick your arguments and everything else through there enough to file in the right court. In other words, you don't want to put everything on there because you do want to have some surprises for court. Because remember, when you file it, they get to look at it, study it, and everything else. But if you've got something you can catch them in questioning, well, as any good trial lawyer will turn around and tell you, hold on to those little nuggets or testimony or anything else. Then you turn around and you hammer down on them. Catching them, like I said, once again, that's your opportunity to question these people of why they did what they did. And they can't claim ignorance of the law, especially a judge, because once again, judges are supposed to be of that highest position and appointed that to their knowledge and experience and be able to apply and understand the law as well as the policies and procedures as they're ruling over. They have to have an understanding. Now, the other thing we point out there, as far as the client's right handbook, how is it that any judge or magistrate across the state of Tennessee, or even in your state where the same thing also takes and they look through it, if they're truly doing their due diligence, why isn't one judicial officer, not one, that I have known of in the past decade or even longer? There's been a few cases where they've gone through it, but then there's non-disclosures in place. But why the hell are all these judges and attorneys going through these cases knowing what I know now? How the hell are you not filing with the state of everything, shutting down CPS for us? And I can answer the question why. Because it's money. Play dumb and make money. Because if you were truly a servant of the law, of the Constitution, truly knew what that oath means and understands that still means something in this country enough to get you put to death for violating it under the acts of treason, especially a judge that has violated their oath. That has to go before, once again, the proper things once they're accused of it. Do not make the mistake, and make sure you clearly articulate, if you're going to use the words like treason or sedition, you clearly articulate with no errors why it is like that, not because you feel. You make a statement, not a question, especially with those. I am hereby accusing you of this based off of this evidence. Make it clear. You can make it clear in court. But now this Rule 60, they says, well, this goes back before your original judge. I think I saw that before. I think Amy brought that up. No, they bring in a special judge, not of your county, generally is the rule of speaking. You can eliminate that by some very strategic planning, we'll call it, creative filing, as some call it, which they do it all the time. I'm going to take every judge, magistrate, even the ones that have ever visited over so many times, or this year's, or whoever's still alive and still able to practice law or sit on that bench. I'm going to be calling them all as potential witnesses. a potential witness cannot overhear a case. You're going to have to bring in somebody from out of the area, way out of the area. Somebody that's never been here before, nobody that's familiar with the politics and all the other crap and all that other stuff. I have now legally tied your hands to where there's no hiding this. The state must come in and the state must rule on their own required everything. And like I said, we painted a picture and it's as clear as a bell. They're screwed. But this is the unknown hearing, a Rule 60 hearing that most people don't want you to know about it. Not anybody. I've not heard anybody out here in the CPS world even talk about this particular procedure. And once again, it's got a different rule number or code number in your state, but things like this do exist in every state. It's just under a different number because everybody has their own way of doing things, sovereignty of states. Some are lazy and it's the same thing, same rule. And you look through it. But once again, read all the stuff in there because once again, you can have that conversation. Somebody says, well, file this for it or do this or what about this or what about that? Does your state even recognize it? And this is why you guys go into the codes. We've tried to point you in the right directions. Read what it says. And if it says something that's been overturned or this or that, just go into it and analyze it. And if you need to, find some other method to help you understand what these codes actually say. Make them, to where they're not so complicated. Explain it to you in plain English. That's a huge thing. Okay. Michelle, if you're going to take and you're going to subpoena something, subpoena the transcripts of all hearings, not just specific ones. Because once again, they don't know what you're looking for. It can be, and once again, this is not legal advice. This is educational purposes only, just so we're clear and very clear, because we are on that line of things. And I'm going to tell you what I've done. Okay, that's where we're going through. This is what I did. And this is what I know about Tennessee and Tennessee law. And like I said, the things that I've done. Have I run it past Tennessee attorneys? Have I run it past this? Yes, I've actually run. I have some great resources, some great friends and stuff like that out there. Connie Reguli, being here in Tennessee, very knowledgeable of Tennessee law. Several other people. And once again, like I said, if you guys don't know, and once again, we don't connect really to a lot of people or a lot of movements. We're just kind of out here doing our own thing. We're going to stay out of all the backbiting and all the bullshit and everything else that goes and has been going around. We're just going to do our show. We're going to continue to educate. And if some dumbass wants to go out there saying misinformation or this and that, listen, you may not be comfortable with it, but at the same time, I guarantee you're not on the level I am and the amount of research and half the other things that I guarantee you this. Is there somebody better than me? Absolutely. But I guarantee you the person that's out there screaming misinformation is not the one. Not the one at all, because they are absolutely clueless, let alone the banner that they wave, especially people I've come in contact with, are the same people that would tell you just cooperate with CPS. And you know what? That's giving in to terrorists. And I refuse to give in to terrorism. Because that's saying you can have your rights so long as you contract with the state. And yes, you get to keep your kids. The point we're trying to make with abolishment is the fact that it should never be that way. As a matter of fact, to even do that is so unconstitutional and so tyrannical, it shouldn't even exist. And that's our argument. This is why Arizona did take and shut down CPS, did reform as they call it, and it failed again, and it got back to where it was before, if not worse. They were just better at covering up. That's being revealed now, even in Arizona. You've got Louisiana looking for stuff to abolish CPS. That's actually on the legislative floor. This has got to stop. And why the American people have not gone into arms, especially with the declassification of the Epstein files, as well as some of the other things that are out there, why we, the people, are not in arms going to take back our children by force under the fact that they had cooperated and provided children to Diddy, that is well known, as well as the Epstein. That's enough. That's enough. That's more than enough in the name of protecting children. That is more than enough evidence to abolish it completely, because they are affecting hundreds of thousands, tens of thousands of children a week, and tearing families apart with just what they do. Nobody should ever have that kind of power. Police to investigate a crime, okay, well, they have this, that, but for what CPS and the way the states have weaponized CPS in every state, absolutely not. Let alone the state of Tennessee. We have you dead nuts and dead to rights that you gave away the rights right in your own handbooks, and even the handbooks you pass out to people explaining we have the right to violate your Fourth Amendment, and you put it in black and white, and now it's on the state record, and it's going to be once again on the federal record again. This is why a lot of people say, well, what happened to the federal case? Well, it changed once we found out a whole lot of stuff, and yes, we are going to work on refiling, but once again, we had CPS of Tennessee and of course the cabinet up in Kentucky interfere with our filings directly, even mention it in their actual state paperwork, that they were retaliating against us. So now we're working our way through, like I said, the courts and everything else. That's why you guys haven't seen much of Sharon to go on. Once again, they took her kids because she was the low-hanging fruit and the easiest to get to, and even put in the paperwork. I mean, this is funnier than hell. I laugh at how stupid they are. They literally put it in there that they're holding the fact that she still stayed married to me. We worked ourselves through our filings. In other words, the due process, that if we fight this, they're going to retaliate against us for fighting this. We need to just accept the judgment. That is a violation of due process, and that's why retaliation's there. And some filings are coming up, like I said, both in Kentucky federal court as well as state of Tennessee court, which was kind of funny to explain some of that too, that another state accused her of violating that no contact order, which never got permission from the state of Tennessee to take over jurisdiction, which violated the UCCJEA hugely. But that the way it's written of that no contact order in Tennessee, I have to initiate, or I have to do something that with the incentive or the frame of mind of violating that order, and anybody else that would participate would be a third party. Well, when they accused Sharon of it, they never put me on the paperwork whatsoever. So for her to do it as a third party, I had to do it primary. Where's my why? Because they don't want me in court. They're scared of me. They are scared to shit of me, of what I'm doing, how I'm doing, and the fact that I'm out there educating people like you of these things that you don't know about, that these attorneys don't even, half the attorneys don't even know about. Why? Because, and here's the reason why most attorneys won't file the 6002 or some of the other things through there, unless they really don't like the judge, or they just don't know about it, is the other thing, is they got to go back in that courtroom and face that same judge. When you file a 6002, you're basically saying this judge is so damn corrupt and evil and everything else, we need him removed. That's like the step to removal, is a 6002 filing. Because you file a 6002, you can get a hearing off of it, sways your way, and the court finds that way. That's an automatic to go to the Board of Professional Responsibility, or a judicial responsibility, or in other states it's called the JCC. It's where you file a complaint on judges saying you must remove this judge because of all this in my one case. It's enough to move a judge. It's that severe. And that's why when you drop this 60, especially a 6002 for fraud, buddy, you've got to be Johnny on the spot. You have got to have your ducks in a row. This is not a mere filing. This is like, I really don't know how to explain it other than the fact of it's like doing pro se, but doing it on steroids. That you've got it down and you just want the court to do the right thing, but now I know you've screwed up. But once again, now I know about a ruling and everything else that even some of the attorneys and everything else won't even bother with. They won't even touch this type of filing most of the time. But at the same time, you're saying, oh no, it's so egregious. It's so much fraud. It's so blatant that they all work together. The judge worked with CPS, that, you know, the GALs worked with CPS. It was 5 or 6, 7 lawyers or something against me and my little old attorney. How is that a fair fucking hearing? And none of you follow the rules, and then each of you cover your butt. That's mass corruption. Well, it's already been reported to, like I said, to the federal authorities and the state authorities. And like I said, that's now, like I said, they're working towards, like I said, investigations of everything. Oh yeah, it's game on. And in case some of you guys don't know, I had the same magistrate and judge Jessica Saxon did. That's affiliated with the justice limits or something like that. I forgot. Jessica's going to kill me because of that. But like I said, we had the same one. We are in no way, like I said, Jessica does her own thing. Saxon, however they do, to all of them, justicewithoutlimits.org. There you go for Jessica, which I think she's just kind of spearheaded this own little thing that she's going on within those things. But once again, our connection personally with Jessica has nothing to do with anybody's movements. We, you know, once again, our own thing. We just stick in our own lane to where we're going to talk about our case. We're going to talk how the Constitution works on this show, what goes on, what things you can look for in your own, how to do your research, how to come up with these things, how to write some of these things, and basically showing you ways of how to deal with your own case, because it's so hard to figure out some of the stuff in your case, because each case is a whole different perspective. Your case is completely different than mine. We may have some similarities, but I hope some of the things that we share with you, you can apply, do your own research, and apply to your own case. That's your choice. Once again, we're not telling you what to do. We're saying, consider this, research it. That's what we're saying. Just so we're clear, you know, like I said, because you're going to have to figure and understand your case. And here's the other thing I've noticed, especially within a lot of this movement here, and we'll be the first one to tell you, I'm not doing it for you. I'm straight up. Why? Because it's not my responsibility. If they're your kids, then you should get off your butt and learn and do the things that others of us have done. Figure out the particulars of your case, apply the law and the things you've learned to fight your own fight. Because when you pay an attorney to do it, they work for the American Bar Association. They have to see the same people, this and that. They're not going to fight like you. Why? Because that's been known in war too. You know, the hardest people to conquer? It's people defending their homeland. And people are scared across, you know, a lot of nations, this and that. They are still scared today to even try to invade this country just because of our Second Amendment and due to the fact that we are so well armed. That scares them. It's not the military. That's our defenses. You hit one, once again, you bring this to the homeland, you bring this to my house, you bring this to my yard. Let's be real clear, and this goes for just, you know, I'm going to say this because for a majority of veterans, a majority of other people that'll stand this thing, there are no rules of engagement. You come to my house and bring that shit to my place. It's all out war. You have declared war, not against just the Constitution with these filings. You've called me out to go to war, and I'm going to give you war. But once again, I think a couple of conversations, once again, as the Marine Corps turns around and says, the only fair fight is the one that you win. You know, you don't play by what's fair, you play to win. I'm not here to say what was fair and what was equal. It's who won. And understand the mentality that we have within this country. And some of you guys that are out there that are military, former military, so on, so you'll appreciate this, and I'm sure you've heard about it. We're the only country in the entire world to ever be investigated. Ever be investigated. I believe it, if I remember right, I do believe it was the Marine Corps, for getting too many headshots. We were too good at killing. We were too good of marksmen not to hit their bulletproof vests, not to do this, not to do that, but literally popping headshots. We had so many confirmed headshots in one engagement. They thought that they were doing something illegal. It's like, nope, they just popped up their head and we took it off. They were shooting at us. We were well within the rules of engagement in war, but they literally went under investigation for being a marksman, for killing that many people, record number in one engagement. That's the power we have as Americans have. We can get so obsessed with something that we just sink our teeth into it. We're not going to let it go, but we're going to be so good at it. You don't ever want to mess with us again. What was that say to other countries? Our basic infantry is so skilled. They're taking sniper shots against the enemy. And we've got this many. Go look up the story. It'll blow your mind. It's all good, Michelle. Listen, there's a lot of things. Once again, the power of subpoena, they can't tell you no. They have to give it to you. But you got, once again, like we've always told you, fight in the right court, fight before the right judge. A Rule 60 hearing is extremely powerful. It's where you can do void ab initio would take full effect. Just file it the different way. And because void ab initio, unfortunately, in a lot of courts' eyes, listen to that and let it roll, go in one ear out the other, prove the void ab initio, but put it under words that they understand, such as a Rule 60 or a Rule 50 or whatever it may be filing. That's exactly where you would argue the void ab initio. Very much so, even without calling it that. You're proving it, but you're very detailed in that filing of saying, had you all had just followed your policies, procedures, rules of evidence, the Constitution, this, and that, ain't no way in hell I should have even, one, been found guilty. Number two, I should have never been in damn court because you committed these acts. And here's the other thing. We're pointing out the fact where you should have picked it up on, Judge, and used that constitutional lens, because had you had done that with everything the state handed over as evidence, you should have had some questions and you should have done your due diligence to protect my constitutional rights and the children. Because now there's federal case law on the record. You committed a crime. And you did it so egregiously, you knew exactly what the hell you were doing. This is a powerful, powerful, powerful tool. I can't even begin to tell you, when we stumbled across it, we were looking at some of the things, how do we get it not just overturned? What if we want to void it? And we went towards the word void. It brought up Rule 60. And we began to research this, and then we began to put this together. And this guy, yeah, we have enough for absolutely a Rule 6002. This subsection, this subject, once again, look at it, read it for yourself, see how the shoe fits. But we'll call it Cinderella syndrome. Okay? To the ball. The shoe fits, right? If what we teach you in the shoe fits, use it to the best of your ability. You're welcome. We're like a shoe store salesman. We got tons of name brand Nike. We've got Reebok. We've got New Balance. We've got this. We got Asics. We got this. We got this. We got the best of the best all through this little store that we're trying to teach you and say, here, try this shoe on. Here, try this shoe on. Here, try this shoe on. Does the shoe fit for your case? Then use it. But you can have multiple pairs of shoes too. You may fit in the Nikes that work great for basketball, but when you're cross training or you're doing some of the training and weightlifting this day, you may find that Reeboks are more comfortable. They fit your foot better. You got to use the right shoe for the right, you know what I'm saying? For the right track, for the right purpose. It's the same thing with your filings. Find the stuff that fits for your case. And hello, Dallas. Good to see you, buddy. If you guys don't know, Dallas and I started out quite a while ago, and I caught on with Dallas when I was on TikTok. And now everybody's got their own opinion, but hear me out with this. Dallas brought me down the trail of understanding a lot of the state filings, a lot of the policies, procedures, a lot of those things, and pointing me where to look and how to do those things. I did my own homework. But then Dallas and I got to a certain point that was beyond the threshold of what he was going, where his purpose was, and some of the things he was teaching and doing. I was getting more specific with my case, and I was looking at different angles that were beyond what the realm of what Dallas's boundaries were. So Dallas and I, once again, we didn't have, like I said, a falling out, or there was nothing wrong with this and that. It was just we outgrew each other, and he had his purpose, I had my purpose. And also understand this, especially with dealing with shows like mine and some of the others, somebody may only get you so far down the road, and they're there in your life for just a season. We need to understand that. And sometimes I truly believe the Creator will bring the right people in your life if things are right, lined up with your Creator, not religion, anything else of this and that. I'm talking about old school everything. And so most of you understand what's about organized religion. Me personally, I don't believe in it. I don't believe it's taught. I don't believe Yeshua, which is the proper Hebrew name that people call Jesus, specifically said, there is now no more Jew, there is no more Gentile, there is no more man, there is no woman, there is no special God's chosen people, anything else. All of that was wiped away, and everybody is on the same level. And that's by that teaching and teaching alone. And it specifically said, learn of me and learn of my ways, not of all these other people that had nothing to do with him, that were deal with nothing but church and church organization, religion. Well, if you want to choose that, that's fine. That's your thing. Me, myself, there are higher levels of saying also, you now no longer have a teacher, a preacher, or anything else like that. That doesn't exist anymore. Why? Because now you're given the paraclete. I leave, the paraclete must come. That gives it a supernatural sense to me. Those are my personal beliefs. So now everybody says, well, what about gathering yourself? Well, that's easy. I'm gathered here with you under a single purpose. All of you guys watching this show, even watching the show later, we're here to come together on common ground. And that is the end of CPS. But like I said, when it came down to that, Dallas and I, like I said, we still kept in touch. We had some other people that have come and gone that we just, like I said, we sifted, and they were just bad people. Just bad people. In other words, they had underlining objectives. They wanted money. They wanted this. They wanted that. Several different methods of this. And understand, yes, there are some that offer a paid advocacy. There's nothing wrong with that. Once again, and there are certifications to get. But when people are doing those without the proper credentials and some of the other things, like I said, to where they back it up saying, no, I'm actually able to do this. I'm trained to do this. I have certification to do this, instead of Joe Smo off of the thing, or people that turn around and, oh, well, I'm an advocate and I've got no certification, no credentials. And how I got my kids back was cooperating with CPS. And now I'm going out there and publishing to everybody out there that this is the way to get your kids and keep your kids in this. And that's by abiding with corrupt orders, unconstitutional orders. And I'm sorry, I won't do that. I won't do that for my children. I would much rather see my children see me stand for what is right, what is true. Having, as we discussed earlier in the show, true honor. This is why I can't address a court until they've proven to me that you do have honor. Show me you have honor. As far as the previous case that I went through with here in Blount County, Tennessee, with both Jason Bedingfield as the magistrate and Tammy Harrington as the judge, and I'm calling them out by name because I don't care. Once again, I already got a death penalty. I got nothing to lose. You're not going to scare me with something. I'm already looking death down the barrel of a gun. Somebody's already got a gun pointed to basically my head because of it, and it ain't you. You don't scare or intimidate me. Why? Because I see you for what you are, a public servant, elected or appointed. You still have to abide. And when you didn't, you wanted war. Well, now you've got war, and now you've got full exposure. And will this be with Blount County, Tennessee? I guess we're going to find out, because here's the other part that goes with once this case is. Sheriff's Department failed to investigate the crime or even take a report. City of Maryville Police Department even refused to take a report or, to constitute the crime, to even investigate the crime. I even went to a state. I have correspondence between myself and a former a state congressman from my district, and reported the crime. At least enough, he was able to call the district attorney and tell him to investigate the crime. What did the dirty district attorney take and do here in Blount County? Buried the crime, and so did his office. Why? Because he shoved it off to somebody else and their head investigator. Oh, we're going to do that. And then the scheduled appointment me and my wife had, they canceled and never called us back. Courts don't have integrity. That's why I can't address somebody as your honor. We've talked about that. We are to have honor, integrity, and respect. If you have people that are sitting on these benches or in these positions that don't have honor, integrity, and respect, and only worship the dollar, the money, their bank accounts, and what they can get, that's a huge problem. That's a conflict of interest, because now it's not in the interest of the people. You shouldn't be sitting on that bench. But we have got to know how to take these judges up. Besides going to the ABA, you have another judge that's of the higher court or the Supreme Court come down, hear your case, and it skips all the bullshit of saying, here, I've made it so blatantly clear they violated everything, and it's all on the record, or it's not even, here's the other thing, it's not even on the record. It's omitted. There it is. You got to know where to fight. But guys, look at that. Research that Rule 60. And once again, it's different in every state. Research that Rule 60 and whatever it is for your state, and see how it applies to your case. This is a whole different story. This is where you bring in the heavy hitters from your state to your county to hold everybody that was in that case, guardian ad litems, the CPS attorney, the whole 9 yards, and put them on the stand and make them fight for their damn lives, their license, their insurance, their bond, everything, including the fact of, once again, putting them on a Brady list because it's so severe, Your Honor. I requested all these people. One, you can make a motion to turn over all the evidence to the FBI and this and that during or after the hearing. You can take and make a motion before the court to make sure that it's recorded, video and audio recorded, and as well as transcribed at the court's cost to be used in further litigation against these particular individuals. It's that bad. You can put it on the state. You got a judge to come in. Yep, we're going to do this. Hey, because why? Now they're on full display. They've got to do something with it, because failure of them to do anything about it with that much corruption, and the temperature's already high with everything else. But now you tie them to, we ended up finding, those of you that are in Blount County, Tennessee, I suggest you go back to the Epstein files, because there's a place close to Blount County, Tennessee, that there was an address, like a county over, of Epstein. And that particular place is a house with a ton of box trucks, housing kids and transporting kids. It's exactly what it was. And let's just say it's close to the place that everybody has high reverence for, is Dolly Parton. It's over in Dolly Parton's neck of the woods, people. You guys know anything about Gatlinburg, Sevierville, Pigeon Forge, all those things, especially during summer? How many people influx to this tourist area with people on work permits, this and that, everything else that's going on? You ever get in with some of those people that have worked or housed or helped some of those people? I have. Kind of sucks when you got somebody that's a master electrician that deals with every walk of life in several counties. You get to know some very interesting people. Let's just put it that way. But guys, I want to thank you very much for joining us. I hope this has helped you guys understand a little bit more of the Rule 60. I know this is really, really, like I said, it's very intense. But like I said, go look at my template, look at it, how it's structured, how it's applied. It's on my Facebook page. It's made available to the public, 100%. Um, I can't tell you enough why this is so important, because some of you may be looking, I'm in the middle of a case and it's just an absolute mess and this and that. Stop everything up to that point and file a Rule 6002. You can do that. Case is over. 6002, within the time frame. But you've got to be able to articulate it in that format to make them look at it and go, holy crap, that's a damn mess. And remember that federal standard. Remember, we read you within the Tennessee code, within a reasonable time. Guys, that thing of up to a year thing does not apply with ADA. Okay? It does not. Because if ADA is applied, how can you physically do that if you're incapacitated? You can't. That goes under common sense. And if that goes back to all the way to the federal court, hey, we'll go ahead and rule on that. But once again, they got to follow the federal laws. They don't get to interpret them. Because you're asking them, did you apply the ADA in the first place? Nope. Well, there's a due process violation like hell. Number two, with ADA, was I able to do things accordingly? This, that. Well, how the hell can I do that if I'm in heart failure or recovering from a massive to have an implant put in, the whole 9 yards? How is that possible? You got to have recovery time. Cancer, heart patients, severe things like that. That's why that's created. This is why the ADA was created. This is why you cite the ADA. I couldn't have made, once again, the federal court says reasonable. Reasonable means physically able. Could you physically? Nope. Couldn't. Miss Alvarez, once again, I'm not an attorney. Should I ask? Should I? That's not a question for me to answer. That's for you to figure out what you need to do and how you do. I'm telling you, it's very powerful. And matter of fact, you can probably research similar filings under the similar codes. If you do a little research of previously filed, once again, rules. You can look in that. And once again, that'll probably be under the Court of Appeals. As it's here. But once again, it's one of those things here in Tennessee. You have to file in the original court. Then it goes up to the appellate court. That way they transfer all the records as too. But it's different than your appellate filing, your Court of Appeals. This is one of saying it should have never been. It's like that severe. Can it stop a TPR hearing? Yes. Everything must freeze if you're filing that, especially if they've already done that and you're in a different hearing. Now you can't TPR. You can't adopt out. You can't this and that. Why? Because you're doing a Rule 60 or something of the equivalent, and you have a reasonable argument that you're wanting to do. Like I said, there's some creative things you can do. In my particular, I'm going to call all the judges, magistrates, and everything else. Why? Because I already know about the buddy-buddy system, and I'm taking all your friends out to where you can't. And I do have some questions for them, especially relating to any kind of relationship. I want to know whether or not they had a relationship with this particular judge, or this one, or this man. I've got questions. I have a right to do that, but it also disqualifies them from ever hearing the case or adjudicating on the case in any matter whatsoever. Absolutely, it violates it. And like I said, even if the lower court decides to, once again, they can't get in the way of this, the lower court doesn't have to give permission. This goes to the appellate court under this particular filing. They get to make that decision. And then once again, they do have to apply the ADA. You have to. It must. And like I said, even to force it, hey, if you want, I'll have it remanded to federal court. We'll just go right into that under a 1983 question. And then you're really screwed because you didn't apply the law. And on top of it, how would you know what the ADA is on top of it? Because you haven't provided any. You don't have that designated employee. Where's your designated employee that was supposed to be there? It's supposed to be regular. It's supposed to be readily available to you at any given time. In other words, it's sitting right in front of you the entire time, that if you need to invoke the ADA, you should be able to do it from the beginning. When the court hides it or doesn't have somebody from the clerk's office reach out, we'll say, which is mostly for somebody in the clerk's office, a designated employee, to make sure you get those by the power of the court clerk, to set the environment the proper way, not just file paperwork. And I almost guarantee most of you, if you go to do with it, because especially we were dealing with stuff in Kentucky, from what we've seen, guess what? It doesn't exist. Matter of fact, they shifted you over to HR. And if you don't know what that means, that's human resources for everybody in state. That is not the designated person. They can't be the same person. If you don't know anything about that, then you need to catch Henry's show, Equal and the Same, on Saturday nights, same channel, CPS Breaking News Network. Well, guys, it's been fun. I hope this has helped you guys out. We're going to take and call it... don't forget to follow us. Like I said, we've got some additional filings I've got to get in, and some amended versions of some things, more evidence to put on. We're just going to stack it on them, man. And like I say, when you do it, don't dump everything. It doesn't have to be perfect. Get your initial on there. They haven't even assigned a judge or a court date yet. So now we got plenty of time. Like I said, time is now an advocate of us, but it's also at the same time, it's making Blount County, Tennessee judicial, including the fact of all the judges that took in Blount County that had signed a thing saying that no recording devices, cell phones, or anything else is allowed in the courtroom. Well, guess what? I had evidence on my phone. And you know where my phone was sitting during my trial? In my truck, because didn't have the availability of all evidence I needed to defend myself because of an unconstitutional order saying I couldn't bring it in without a judge's permission. You never need a judge's permission to bring evidence in. That puts down and proves everything that now that entire courthouse has been unconstitutional since that has been posted, and you have violated the fact of anybody that goes in there doesn't have the ability to defend themselves to the best of their ability because you have delegated certain things that may or may not have evidence on it, saying you just can't. That's an illegal order. That's an unconstitutional order, and it's a violation of due process for anybody that walks in that courtroom. That's why they want me. That's why they want to come after me. That's why they want to attack me. That's why they're so hardcore against me. Why? We have enough to tear down CPS, especially in Tennessee, and we're working on Kentucky at the same time. By the time we get to federal, it's going to be all on the record, and you're going to have fun because I believe there's going to be cameras in the courtroom. I really do. And then we, the people, can now call out everybody on top of it because we have connections to Epstein and the whole 9 yards with our CPS. That's right, guys. We got it. It's enough to tear it down. It's enough to hold them accountable. It's enough to bankrupt them. Keep an eye out what you can do to do your part and do your filings. Spend the time. Spend the time getting the education. Every waking hour, everything you have, educating, pulling it in, figuring out what works for you. And then get together with some other people and look at some other filings. Educate yourself, man. Knowledge is power. You guys got to understand that. But guys, thanks again. We'll see you again next week, 9:30 p.m. every Sunday Eastern Standard Time here on the YouTube channel, Gunning for CPS. Have a great week, and don't forget, whatever you can do, piss us off this week, especially if it's CPS and the judicial system. Have a great week, guys.
When the last courthouse falls and the last black robe burns, when the last caseworker flees and the last stolen child returns, we'll raise a monument on the ashes of their throne, carved in Tennessee granite with these words alone. Here died tyranny at the hands of a dad and mom. The reckoning came, 2020 seats the storm.
This is the reckoning. Gunner Everest poll it loud. Blount County in ruins. Kentucky in a shroud. CPS is finished. Hear the death knell ring. Every stolen child coming home.